So I'd like to welcome our panel, can come on up with us here as they join us. I'd like to confess that I'm probably the worst person to be running a compliance panel. My ambition has always been to move fast and break things. In a background of a number of years working in the world of contingent workforce, I've always had hiring managers who just need to get the work done, and I've had employment legal who absolutely tried to stop me from helping them get the work done. But today's panel, we have an esteemed guests, and they're all focused on enabling people to get work done, but ensuring that compliance isn't a separate process, but compliance is part of the process, which I think is integral to what we've been hearing today. So I'd like for each of you to introduce yourselves.
Hello everyone, I'm Matt. I head up operations and business affairs for VaynerMedia. For those that aren't familiar, we're an independent creative and media agency, founded in New York by entrepreneur Gary Vaynerchuk, if anyone knows him. And we are around 2,000 people globally, split across 15 offices, and we work with freelancers to kind of scale up our model. I've worked in legal and kind of operations for numerous years, different agencies. I actually used to work with Joe, who was on the previous panel at RGA. So yeah, very pleased to be here.
Hi, I'm Rebecca Seeley-Harris. Professionally, I'm an employment status IR35 and off-payroll working expert. I've been doing it for 25 years since IR35 came in, and I do it from a tax perspective and also from an employment rights perspective. I was a former senior policy advisor with the Office of Tax Simplification at the HM Treasury, and I was the government's expert on employment status, where we did various reviews on employment status, on small company taxation and the gig economy. I'm also the chair of the independent arbitration panel for the FCSA, and I'm on the industry working group for the new umbrella company policy, and I've just written a paper on it.
Follow that. So I'm Caroline Jones. I've been in tax for 47 years. I'm an ex-inspector of taxes. The ex is the really important bit for today. But I've been working for Big Four. I've been an employment tax director, and I've been specialising in off-payroll working. Got quite a few years' experience because I was the expert for the firms that I worked for in terms of higher education. So, of course, they were public sector, so they went into the off-payroll working regime in 2017. So, hopefully, I've got something to add today.
Hi, I'm Fiona Coombe, and I'm Director of Legal and Regulatory Research at Staffing Industry Analysts. SIA, for anyone who doesn't know, is the global advisor on contingent workforce solutions. I've been with SIA for about 11 years, and I was head of legal at Recruitment and Employment Confederation before that. And I'm pleased to say I was a freelancer for 3.5 years between those two.
Fantastic, thank you very much. Let's start with Caroline. What's the most common mistakes that we see companies making when it comes to off-payroll working? And then what's one quick fix we could make right now?
So I think that the biggest mistake is not training staff to understand off-payroll working, particularly not involving procurement as well. So I think the biggest issue that I've seen when I've been dealing with clients is that that process of looking at off-payroll working from a tax perspective is not embedded. And so some people might have some great areas of expertise, but what you see is that it's not consistent across business. So obviously the easy answer to that is involve procurement at the outset because they know exactly what you're looking for, and also make sure that you give regular training. And I think that the rules have changed over time, so it's really important to keep people up to date with that training. And if you do that, it will pay dividends, particularly with hiring managers. So HMRC ask all the time if they're doing any sorts of reviews, we want to speak to the hiring managers, what do they know and what do they do? So I think they are very important in the process. So training, training, training.
Matt?
I've seen blanket policies of just don't work with personal service companies and like freelancers that operate that way. I mean, someone already mentioned in the panel this morning that, we've seen a huge shift, certainly, during COVID and post-COVID, of freelance talent in the market. Obviously, working in the creative industry, we're seeing a significant number of top-tier talent who operate as freelancers. And as a company, if you had a blanket ban on working with personal service companies, then you're just not going to get access to those top-tier talent. So that impacts, obviously, the ability to do the best-in-class work. So I'd say the solution to that is to remove the blanket ban, firstly, but to just get comfortable with how you comply with the off-payroll working regulation. Don't be scared of it. We're here to work with it. And, I say this to the team, let's assess each person based on the facts, and let's just, take that approach.
But what do we think about getting the hiring managers really comfortable with the process of off-payroll workers?
Well, I think, one of the problems is actually all the departments, and a lot of the work that I've been doing with clients lately is getting all of the teams together to understand the communication processes within the teams. So you might start with, you've got procurement, you've got legal, you've got tax, you've got HR. They've all got different agendas and they've all got different points.
When we think about what good looks like out there, and when we're building internal policies, building policies is hard enough in itself, and then we've got to make them interpretable to hiring managers and to the business to actually understand what this governance can be. From a practitioner perspective, what can we do about that?
I think there needs to be clear accountability and responsibility of your workflow internally. So one of the things we're continuously looking at Vayner is, across all our operations and our workflows and our processes, implementing a clear RACI. So who's responsible, who's accountable, who needs to be consulted and informed as part of that process. And I think, by implementing robust policy, so when it comes to working with freelancers, you need to agree as a business, do we offer them benefits? Do we, give them a work email address? Do we, invite them to, work socials? All that stuff is important as part of the company policies that we have around freelancers. So, and I think as well as that, the education piece is really important. Obviously, attrition happens within a business. So, and we spoke in the kind of pre-meet on this of information falling between the gaps. So not having that kind of education would lead to that.
There were some grimaces here on the panel when you were mentioning some of those comments. Would you like to share more about how you were feeling there?
Well, actually, in the last panel as well. I think the problem is, as an expert, obviously you're looking at it from a different perspective, and things change a lot when you're looking at the case law, and you've got to implement that within a business, and you've got to get the businesses to really, really understand the differential between your freelance talent and the people that you employ. And I think on the last panel, somebody was talking about, the contractors being in a separate room. Great idea. I think, the problem is that as businesses, you want to do the right thing by a human being, and you want to make sure that your human beings who are working with you are comfortable, and you want to, it's all very touchy-feely and mental health. But the problem is, from the advisor's point of view, you've got to be at arm's length. And the main point with working with the teams within is keeping up with the complexity, keeping up with the case law, keeping up with the procedure, having a dedicated position. So one person should be in control of the process, and then whether it's an employment status officer. And in fact, actually, that's one of HMRC's recommendations in terms of taking reasonable care.
And it's interesting when you say that. I think one of the unintended consequences we've seen across all industries is we've heard about people being badged differently. We've heard about people being locked out of the room. We've heard about people not being allowed to attend events or certain meetings. And ultimately, then we've got our hiring community who absolutely disagree with that, right? They see these people as humans. They see these as integral to doing the work, and they see them integral to generating revenue. And when it comes down to it, if somebody's in a role that's generating revenue for the organization, it's going to happen.
Employ them.
I take a slightly different view to Rebecca. SIA takes a global view of compliance because a lot of our members are trying to run global programs and trying to be compliant across different jurisdictions. I think it's understanding what works in what jurisdiction. I spend my life talking to members who are running a program here in the UK who are talking about co-employment. Well, co-employment doesn't necessarily apply here in the UK. And so, yes, in the US, it's a major consideration when you're talking about agency workers, for example. Things like misclassification. The law around employment status is pretty much the same wherever you go. The basic tenets are don't control, don't direct, don't supervise the worker. And if you start from that basis and then work out, whether the particular jurisdiction says if you give somebody a staff lanyard or a email address, is that going to have an impact? My view is generally no, but I'm happy to have a good, healthy discussion with Rebecca later.
Can I just make a point there, because I think I agree with both of you. So the thing that you need to do when you're looking at whether or not somebody's an employee, it's not just one thing, you're building up a picture. So it may be that perhaps you provide some sort of mental health support or something like that. That on its own would not make that individual classified as within the rules. But when you're building up a whole picture and you see these sorts of things happening, that's when HMRC get really very interested in it. So the other thing, I think we touched on it, was earlier on, I think we were talking about shifting between employee and freelancer. And that too is an area that HMRC are really interested in. Doesn't mean to say that you can't do it. So if you've got an employee who becomes a freelancer, it's not that you can't do it, but you have to be able to draw a really clear distinction between what they're doing now and what they were doing before. Otherwise, HMRC would say, well, why? Is it just a matter of choice? And employment status isn't a matter of choice, it's a matter of fact. So I think, yes, it's not just one thing. You need to look at the whole sort of engagement and what you're providing and what you're doing. People get really excited about email addresses. Oh gosh, they've got a Works email address. On its own, that is not an issue. But when you start to build in the other things, it can become an issue.
Oh, 100%. And I don't disagree with the fact that should they be employed, should it be a temporary worker, whatever the engagement is based on certain criteria. But I think the challenge for us all is that you have hiring managers. And when we were prepping for the panel, we were talking about Gary Vee and how he travels around the world and his brand. And I think you were describing the fleet of freelancers that travel everywhere with him. And I think, how would that conversation be handled internally for you if you were just employed him?
Good question. I think we rely in terms of, we operate quite a lot in markets where we don't actually have a corporate structure. So to give an example, we worked with Visa on their Paris 2024 Olympic and Paralympic work. And part of the campaign was to scale in markets such as Poland, France, Spain, Italy. None of those countries we actually have a corporate presence. So the ability to scale up in those markets, I'm certainly not an expert when it comes to those markets. So to kind of, it's an interesting one in terms of how do we achieve that level of compliance. And we always see that from Gary Vee a lot in terms of just the speed that he works.
Yeah, absolutely. And I think speed is integral to how we all work and how all of our hiring managers are working. When we do lean in and we do look at how do we manage compliance internally, how do you think that it should be done? Should it be centralized? Should it be outsourced to experts? How do we get the balance of this right?
For us, it needs to be outsourced. Not because we've got fantastic people in an experienced team, but using that example of operating in markets where we don't have a presence, the ability to outsource that firstly allows me to sleep at night. So a level of reassurance, but it just gives us that sense of achieving scale fairly quickly. So yeah, it's important. And
well, I mean, obviously, I'm going to say you need to hire an expert and outsource it. I mean, it goes without saying, doesn't it? In all seriousness, though, in the 25 years that I've been doing it, things have changed a lot, and I would say probably actually quite dramatically in the last 6 months. And I think that the case law and the fact that HMRC has now got 5,000 more compliance officers, thanks to the government, it is absolutely essential that you have not only an outsourced provision, you have a management process. So you need an expert, you need a management process, you need an assessment process, you need somebody who's taking control, a dedicated role within your business that is taking control of employment status, because it's such a big issue. It is one of the government's imperatives to close the tax gap. So this is an area of payroll working that the government are focusing on. They have tasked HMRC with focusing on the compliance by giving them all these additional compliance officers. So I don't think it's possible now for somebody to do it internally, because unless you're a case law expert and you fully understand what changes there have been made since POGMOL, if anyone knows what POGMOL is. So the case that went through the Supreme Court, which is an extremely important case post-POGMOL, since then we've had 7 cases go through the tribunals and HMRC has won every one of them. Do you know what all those cases are about? So that's the point. You need to bring somebody in who understands that, and you need to use the systems that are available. Obviously, Worksome is one of them.
Fiona, from your perspective within SIA and the large enterprises that you're looking at, how are they thinking about this, or how are you talking to them about this?
About whether you have compliance sort of in-house or outsourced. I think it depends really on your capabilities within your compliance team. I mean, I used to be a lawyer in private practice, and when a client comes to you, you know, the first thing is you have to find out about their business to understand what the issue is that they're litigating over, for example. When you have an in-house team, they understand the business from the get-go, hopefully. Of course, there's always an element of having to explain the issue. But, you know, I find with the contingent workforce space, if you can find, for example, lawyers and advisors who actually understand the industry, as opposed to understanding the specialist legal area, then you've got a head start, because you don't have to explain what an agency worker is, what an independent contractor is, why you're hiring them, how you're hiring them. They understand that from the beginning.
How well on the explaining piece of what these different worker types are at a high level inside the organization, definitely people get it. I think when it translates through to the business and through to the hiring managers, how are companies starting to think about it, or how are people starting to be able to explain not just the worker naming convention, but actually the work that they're doing so that they can get them into the right bucket?
I think, you know, you've got to explain to your hiring managers why they need to do things in a certain way, and you've got to demonstrate that there will be efficiencies, there will be cost savings, that they will get work done faster, but they have to make sure that there are certain guardrails that they put in place and that they don't overstep those, don't tell the worker, you know, the contractor what to do in terms of their work, don't give them performance reviews, that sort of thing, you know. But just get them to understand that compliance is a part of it. It shouldn't be the starting point, but it should be part of the conversation.
And I think to back that up, one of the things that I've seen quite a lot is using questionnaires for those hiring managers. So some really pertinent questions to ask at the start. So you're almost triaging the person that you're taking on to say, which direction are we going in? And so it doesn't have to be pages and pages of questions, because nobody wants to do that. But there could be some sort of, say, perhaps 8 to 10 questions at the outset, which will help the hiring managers make a decision about which way they need to go.
And I think specifically when we think about, and we've been having these conversations this morning around the freelancer, the manager typically starts with the worker, right? So in comparison to conventional hiring, where we've got, you know, I need a permanent hire, which is I've got headcount in my team, I open up a requisition, interview some people, or I've got a temporary worker hire, which is relatively similar. We're now seeing so many more managers that are starting with a human, and then they're moving towards what work they want to get them to do. Mm-hmm. And we've heard earlier on, the work is probably already happening right now. How, Matt, you know, from your perspective internally, do you help ensure that that work still happens right now, but also add in the compliance steps and make sure then that things are underpinned, we'll say, by compliance as it goes along?
I think effective communication as early as possible. I'm constantly trying, and it's always difficult. We worked, you know, on a significant volume of projects only work, which means that quite often the teams will say, okay, we need to start the work next week. Or for anyone that works within creative media agencies will know that quite often we need to bring someone in tomorrow, because that's just the way it works. But we can try and mitigate that by bringing an effective communication upstream, just to have a conversation of how do we make sure that the workflow is followed accurately, and we're operationalizing that process, which of course includes compliance.
And from from the tax perspective and the employment law perspective, if you're putting yourself in the operations team's shoes, how can we take away some additional tips on this for those hiring managers and getting them in that place?
Well, actually, that's a really interesting point because it's one of the updates that HMRC has just produced in the last couple of weeks, which is called the dominant features test. And that is specifically on, are you hiring a person? Is the dominant feature of the contract about the person or is it about the work? So the problem is I come at from quite a sort of clinical angle, I suppose, and I'm looking at saying, okay, well, is this about the work? Are you just trying to get the work done? Or is this about the person? And that's one of the really critical points in compliance in employment status at the moment, is how you approach the onboarding for the work, whether it's a project, it's got to be project-based rather than personal-based.
And if we can stick on this just for 1 second, because I think what we're hearing externally is more about skills-based sourcing. And the skill is part of the work, but it's also part of the human. How, is there a way or is there a future where HMRC start to understand that there's a connection point between both, and that it's, I have a person, they have a skill, it's also the work that they could be doing, and it's very, very blurred for those hiring managers who, let's be honest about it, are not intentionally going out and trying to put their company and organization at risk. In fact, most of the time, they're trying to do the very, very opposite.
Well, I mean, that's the problem, isn't it? Because there's competing agendas. And, I've worked with HMRC when I was a senior policy advisor, and I'm very lucky that I understand the complexities of compliance in this area from all angles. HMRC are not there to give empathy. They're not there, that's nice. That's not their job. Their job is literally to look at the case law, and they keep winning. And they are very strategic in terms of the case law that they're bringing. So, no, I don't think that, the questions that I'm seeing coming through, and this is one of the problems, once you're into an investigation, informal or otherwise, it goes on for years. I've got one client, 14 years. So they keep asking question after question after question. And the questions they're asking at the moment is, what is the dominant feature? Whether the companies want it to be skills-based, and because we're in a different area in terms of companies want to be good to their people. That's brilliant argument for HMRC, unfortunately. And I don't see that that the gap isn't going to be closed because that's not HMRC's job.
I definitely agree with that. I think HMRC just look at the bald facts, and the nice things that you want to do for freelancers can work against you sometimes. And as Rebecca says, once you're in inquiry mode, then it could go on for years and years. I think my biggest concern at the moment is the 5,000 extra investigators, because HMRC has got to train them. And so what I've seen is quite often HMRC will send you a request for information, say they want it within 30 days, and you work really hard to get the information to them, and then they don't respond to you for another 6 months. So I think we're going to see more of that. I think we're going to see more reviews of payroll working, and I think that it's going to be taking longer whilst HMRC investigators getting up to speed.
So with the 5,000 additional individuals coming and starting to scrutinize businesses across the UK, what are the things that companies can have in place now that could at least help give HMRC a sense of comfort that they are doing something about this, and therefore maybe reduce the risk of being further investigated?
So definitely need processes and policies, and they need to be written down. I often see organisations where somebody has got all the knowledge, but it's not written down. So if they left, it all goes with them. So I think definitely do that. Keep an audit trail, really important. So if HMRC did come to see you, you could explain why you've arrived at a particular decision. Being consistent is really important too. But the other thing, based on a little bit of what I heard earlier, is you should be reviewing your decisions on a reasonably regular basis. And the reason for that is, I think somebody really nicely said that somebody could offer additional services that were sort of not the same as their original engagement. Well, do you test employment status at that point? Because something's changed. So HMRC would expect you to do regular reviews. Most of my clients, I would say, probably did them every 12 months, and that ought to be enough. But, alarm bells start ringing if you're doing them every 12 months, and 2 years down the line, you've still got the same freelancer. because things morph, don't they? You set up an original engagement and they get really familiar with your business and they're really valuable to you, and suddenly they become embedded. And so I think that's where we're going to have issues going forward with HMRC. So policies, procedures, audit trail, and regular review.
And that's what's such a challenge, right? When you have a really good freelancer that becomes part of your business, right?
Yeah.
Part and parcel.
Part and parcel.
Yeah.
So actually that kind of, you remove that kind of human layer of actually, we actually just need to reassess you again because we just need to tweak something in the project. So yeah, it's an interesting balance, but.
And isn't that annoying for contractors? Because, if they've been with you a while, they're thinking, why are you doing this all the time? Or maybe we're doing some work somewhere else and it doesn't get done there. So there are lots of challenges, I think, around freelance. But it doesn't mean to say that you can't engage them. You just need to make sure you've got the process in place just in case HMRC come to see you.
Yes, and the other thing is don't just call it a statement of work and think you can get away with it.
No, and I totally agree. And I actually had personal experience of dealing with HMRC prior to IR35 being launched in another role. And the way we approached it was we actually documented all of our processes, we put everything together, we scrutinized CEST, and we identified weaknesses in the CEST process for our business. So one of our business was that we had contractors coming in who were going to access data, but it was customer data. So we had a conflict between data privacy and IR35 and the do you bring your own tools? So we fired the questions back at them and we proactively went to them and supplied them with a ream of information because we felt that we were on their first list of the top companies that they were going to come to. And rather than wait for them to come to us, we actively went out and said, here you go, we want to get on a call, we want to talk to you, we want to scrutinize these questions, and here's our specific use cases as to why we believe these workers are outside IR35 but are getting determined either in the grey area or they're getting pushed potentially into inside IR35, which is not exactly correct for our use case. And the feedback we got from them was, and potentially we were lucky with the person we were dealing with, was that they were incredibly engaging. They respected our decision and they really liked that we had taken the approach and we did not get in that first tranche of audits attacked, which was a blessing. Coming up close on time, coming up close on lunch. Very quickly, I'd like to ask some of the panel about one shift or change on the horizon that businesses should be preparing for today. Rebecca, liability shift.
Yes, well, this is the umbrella company shift that's coming in April 26. Currently, it is what's called option 3, which is the change in the deemed employer. So within the labour supply chain, if you've got the end client and they've got an umbrella company in the chain, the tax liability is currently going to shift from the umbrella company to the employment business or the recruitment company. If there's no recruitment company in the chain, then it will shift to the end client. What that means at the moment is that there is going to be quite a dramatic shift in terms of how companies work with umbrella companies. And the whole point is to create more compliance within the umbrella company. You're still going to be able to work with umbrella companies. The problem is, and I find it really difficult, is that we don't know exactly how the policy is going to work. We're going to get more information in July when the draft legislation comes out. And this is actually an area which I've been working with HMRC on to say, you should have had the policy, you should have known what the details of the policy were before you brought it in so everyone knew what they were doing. So there is going to be, it depends on how they do it. There could be quite a dramatic shift or it could be business as usual. There's going to be a change, we just don't quite know what it is yet.
Caroline?
Well, I'm going to cheat because it's something that's already happened, but it's going to have an impact, and that's the change in the rules in terms of turnover. Employee numbers have stayed the same, and balance sheets. So you'll all be aware that if you meet 2 out of the 3 criteria, then you are obliged to operate the off-payroll working rules. So the thresholds have gone up from the 1st of April 25, but it means that you have to be 2 years below the limits before you can actually opt out of off-payroll working. But that's something that you really need to be thinking about now, because if you are likely to have the opportunity to opt out because of the nature of your business, turnover, etc., it probably won't hit you till 27, 28. But you're going to have to explain to your freelancers if all of a sudden you're no longer operating off-payroll working, the onus goes back onto them. So I think that's the change for businesses to think about.
Fiona?
the Employment Rights Bill, which is going through Parliament at the moment, I think that's something you need to be aware of. The concept of giving your agency workers guaranteed hours after a period of time, but more damagingly, probably the concept of having to give notice of cancelled shifts and or compensation for cancellations or curtailment of shift for your agency worker population.
Fantastic, thank you all. I just want to say a huge thank you to our panel today.